Chili gets a win. Chili gets a win? When? When he made a late filing, of course. Jose Chili DeCastro gains the ability to serve Josh Abrams, Kate Peter, and Dale Lackluster Hiller via email as his 60-day extension is filed and granted. Then is awarded another 60-day extension in his lawsuit against 2 Nevada judges. Is there anything he can't do? Frauditor Troll and Denver Metro Audits disagree on the merits of the first amended complaint in DMA's lawsuit against the Canadian YouTuber. Will Randall S., the unhinged Attorney Newman, Esquire's filing, prevail? Regan Benson pleads not guilty to the crime of harassing a Denver police officer. Will they ever break her stride? Will they ever slow her down? Craig Hendry says he'll be on mock trial in December for charges out of Greene County, Indiana. Is the system really rigged against him? Plus, Jeremiah Payne gets trespassed from a Kroger's supermarket. Did you have Tennessee tee-hees on your scorecard? I'm your illustrious newsreader, Pence. You're a double peanut butter and salami sandwich on bread made with oats and honey. Are your private eyes watching as I gobble you down and we're enriched in the goodness of auditing insanity? Oh my. A new filing by Jose Chili DeCastro on Monday saw the YouTuber again ask for a second extension in serving Josh Abrams, Kate Peter, and Dale Lackluster Hiller as part of his defamation case in which he is seeking $1 million in damages from the trio. The lawsuit stems from a pair of live streams involving defendant Abrams. Abrams was joined by Peter and Hiller in a 2022 live stream where they made a number of statements about DeCastro that were based on loosely known rumors about DeCastro at the time of the live stream. Some of the rumors proved true. Others proved to be false. A second live stream held in 2025 saw Abrams acknowledge that DeCastro was suing him, and that further disparaged the YouTuber. According to DeCastro's amended complaint, filed before attempts at service, he lost around 400 subscribers following that broadcast, showing that his brand was damaged. DeCastro's inability to find the 3 defendants, other than statements that he searched online for their information, has been problematic, with his claims of having exhausted all means of tracking their mailing addresses down. No evidence was provided that DeCastro did any of the searches or exhausted his ability to find the defendants. While he had previously been granted a 60-day extension to serve the defendants, and likely will have his second request granted, DeCastro is attempting to set the stage for email service. Copies of emails DeCastro sent to Peter, Hiller, and Abrams with the service paperwork were included in his previous request for an extension. They are missing in his second attempt to do so. Instead, DeCastro changes tactics, laying out that Abrams acknowledged the lawsuit in a live stream. To prove that Hiller is aware of the lawsuit, DeCastro took a different tactic, this time claiming, "On August 30, 2025, plaintiff conducted a YouTube live stream titled, 'What to Do When You Are Pulled Over, We Don't Stop,' on his Delete Laws channel. During this live stream, at timestamp 2 hours 48 minutes 5 seconds, plaintiff discovered that defendant Dale Hiller, who operates online as Lackluster, was present in the audience after someone gifted Hiller a free channel membership. A screenshot of the video showing the relevant timestamps with a YouTube transcript panel is attached as Exhibit A. The complete video remains publicly available on YouTube. The circumstances surrounding Hiller's presence demonstrate both the irony of his conduct and the appropriateness of alternative service. In the video that forms the basis of this defamation action, Hiller stated that plaintiff's M.O. is to sit in the crowd and just lurk and not add anything to the comments if he's not the main topic of discussion. Yet, on August 30th, 2025, Hiller did precisely what he falsely accused plaintiff of doing. He sat silently in plaintiff's live stream audience, contributing nothing to the discussion, lurking without comment. Only the automated notification of his gifted membership revealed his presence, indicating he was intentionally monitoring plaintiff's content anonymously. Upon discovering Hiller in his audience at timestamp 248:05, plaintiff immediately attempted informal resolution. At timestamp 248:12, plaintiff directly addressed Hiller during the live stream. Quote, "Lackluster, check your email, man. Check your email, dude. Check your email, dude. Lackluster, let's close the gap, man. Let's close the gap. Let's end this. I sent you an email, dude." Unquote. That's Exhibit A. Despite being present in plaintiff's live stream when these settlement overtures were made, and despite plaintiff's direct public appeal to check your email, Hiller did not respond to either email. Hiller continued to monitor the live stream silently, lurking in his own terminology, but refused to engage in settlement discussions or provide an address for service. Plaintiff also contacted Hiller's attorney, referenced in Abrams' fundraising video, who similarly did not respond to inquiries about service or settlement. DeCastro offered proof of Hiller's presence at his live stream that day, with an exhibit showing the transcription of his comment announcing that Hiller had received a gifted membership to his channel. He did not include the list of chat participants showing that Hiller was participating in the chat. Furthermore, DeCastro's claims are problematic at best, as gifted memberships on YouTube are distributed randomly. Those members who purchase gifted memberships for others do not have the ability to pick the recipients of the gifted memberships. As the awarding is random, membership gifting is loosely open to anyone who has ever visited the channel, participated in chat, or watched a video on the channel. Presence in the chat for the live stream where the gifted membership was received is not required. To show this, we conducted our own experiment on Monday, November 3rd, 2025. YouTube awards content creators the ability to gift 10 gifted memberships a month. As with all gifted memberships, when awarded, they're distributed to random individuals who may have tangentially browsed the channel at some point in the past. We distributed 10 gifted memberships in 2 groups of 5, with none of the recipients of the gifted memberships being observed in chat at the time of the gifting. This is not the first time DeCastro has failed to understand the nature of gifted memberships. Famously, in 2023, as he was falling out with former channel partner Colin Campbell, he discovered that a membership had been gifted to a channel he considered to be run by one of his enemies. He accused Campbell of directly gifting the membership to that channel and used the fact as part of his need to sever ties with his former partner. While offering statements showing that he believes Abrams and Hiller have knowledge of his lawsuit, DeCastro ignores defendant Kate Peter completely, offering no proof of attempts at service or her public acknowledgement of his legal action against her. DeCastro has previously successfully served Peter and Abrams with an unsuccessful 2022 federal defamation lawsuit that later morphed into a copyright infringement lawsuit against YouTube. He also attempted to serve Peter with a California-based defamation lawsuit in 2023, which saw the clerk of the court hold Peter in default for not responding to successful service. The YouTuber has yet to attempt to turn the default into a default judgment against Peter. As he was ignoring a third of the defendants in the case, DeCastro confusingly parroted wording from his own lawsuit against John Irish Demon O'Day to justify email service in this case. Email service was granted in that case, as it was shown that O'Day had provided a false address in his response to DMCA takedown notices by DeCastro. It also involved a client living overseas and made a coherent case that showed O'Day openly acknowledging the lawsuit in a live stream. Other than DeCastro's statement that he attempted service and couldn't find addresses for any of the defendants to initiate service, he offered no real proof that the defendants provided false information or circumvented the service process in any way. In the end, DeCastro is asking the court to find good cause under Rule 4M for plaintiff's inability to complete traditional service on defendants, grant a 60-day extension of time to complete service of process on all defendants, authorize alternative service on defendants Dale Hiller, Josh Abrams, and Kate Peter by email to their known last email addresses and direct message through their YouTube channels and associated social media accounts. Order that service by these alternative means shall constitute valid and effective service under Federal Rule of Civil Procedure 4 and Massachusetts Rule of Civil Procedure 4, and grant such other relief as the court deems just and proper. DeCastro's new filing did nothing to spur the crowdsourcing market, which remained in goose egg territory for a second straight day on Tuesday, as no donations were observed, including to DeCastro's 3 ongoing campaigns. And now, a late-breaking update. Perplexingly, Judge Leo T. Sorkin gave DeCastro both the extension and the ability to serve by email. Judge Sorkin wrote, "For the foregoing reasons, DeCastro's request to serve defendants Hiller, Abrams, and Peter by email, and his motion for an additional 60 days to effect service are allowed. DeCastro's deadline to serve is now January 2nd, 2026. DeCastro shall timely serve each named defendant by email with a summons, a copy of the amended complaint, and a copy of this order. DeCastro shall thereafter file proof of service with the court showing that service was made in accordance with this order. That proof of service shall demonstrate that the email address used for each defendant is the defendant's valid personal email address." This is a breaking news story. Christopher Denver Metro audits Cordova's ongoing lawsuit against Jonathan Frauditor Troll Who Know returned to the news on Monday when Cordova's attorney, that Randall S. the Unhinged Attorney Newman, Esquire, filed an amended complaint on his behalf. The amended complaint was filed and followed the agreed-upon outline by both sides in the ongoing copyright-related lawsuit last week, with Newman filing an amended complaint, and then Who Know, through attorney Steve Vondran, filing their motion to dismiss the lawsuit later in the month. Newman's updated complaint displays a significant makeover from his 2 previous service complaints, adding Who Know's Company 146936663 Canada Incorporated as a defendant, and interspersing Who Know's own claims and comments from the multiple live streams the defendant has done on the subject since the beginning of the lawsuit. Some of the key highlights included Who Know's apparent admissions of deleting 1,700 videos from his channel in an attempt to prevent their use in further lawsuits, Who Know's alleged unlawful circumvention of YouTube's anti-piracy software to download Cordova's videos, Who Know's bragging that he defeated 48 copyright strikes and used boilerplate statements in his counter-DMCA notifications. Should his side prevail, Cordova is seeking A, that judgment be entered in favor of plaintiff and against defendants for monetary damages caused by their infringement of plaintiff's Another Chad and Belmar Library copyrights. B, that judgment be entered in favor of plaintiff and against defendants for monetary damages caused by their knowing material misrepresentations in the counter notices pursuant to 17 U.S.C. Section 512F. C, that the court enter a declaratory judgment that defendants' use of courthouse fail is not protected by 17 U.S.C. Section 107. D, that judgment be entered in favor of plaintiff against defendants for their unlawful circumvention of technological protection measures in violation of 17 U.S.C. Section 1201A, including statutory damages of $2,500 per act of circumvention, actual damages, attorney's fees, and a permanent injunction prohibiting further circumvention or distribution of works obtained through circumvention. E, that the court enter a permanent injunction enjoining defendants from further use of Another Chad, Courthouse Fail, and Belmar Library, and requiring YouTube and any third-party platforms to remove the infringing videos and prevent further dissemination. F, that the court award plaintiff costs and attorney's fees pursuant to 17 U.S.C. Section 512F. G, any other relief the court deems just and proper. And now the updates. A status update hearing was held on Tuesday that set a path forward for the lawsuit, including officially setting a trial date for February 1st, 2027. Both sides released their reactions to the scheduling order and the amended complaint on Wednesday. Cordova went first and was joined by Attorney Newman in a live stream held on Wednesday afternoon. The pair, who were both present at the status hearing, indicated that Attorney Vondran attempted to argue facts at the meeting and was immediately shut down by Judge Virginia K. DiMarchi. They also asserted that DiMarchi attempted to dissuade Vondran from filing a motion to dismiss the lawsuit, as his side would be unsuccessful, since she wanted to hear debate on some of the claims. Newman thanked YouTuber Dr. Dave for his assistance in the lawsuit. Both Cordova and Newman stated that a lawsuit previously filed against Dr. Dave's friend Gail Bouma was voluntarily dismissed based on his actions. They otherwise rehashed the new additions to the first amended complaint and mocked statements that Huneau would win the lawsuit and somehow place a lien on Cordova's condominium. In a video released shortly after the livestream, Huneau indicated that the lawsuit would likely be over in 2 months after the judge rules on their upcoming motion to dismiss. He insisted that he and his attorney would double down on defending his work as parody and would prevail on the misrepresentation, declaratory relief, and circumvention of technological measures. While he was unsure if the copyright infringement claims could also be wiped out by a positive ruling on his motion to dismiss, he reassured his fans that he would not be settling the lawsuit or paying Cordova any money in a settlement. Huneau also shared his expenses from the lawsuit and thanked his fans for contributing roughly $18,500 Canadian to his cause. He has been billed $24,659 from legal fees, split between attorney Patrick J. Darcy, who initially consulted with Huneau, and attorney Vondran. The Canadian YouTuber is expected to file his motion to dismiss later this month. Monday's filing for an extension to serve the defendants in his lawsuit against Kate, Peter, Josh Abrams, and Dale Lackluster Hiller was followed by the posting of a similar filing by DeCastro in his case against nearly everyone who was involved with his incarceration in Nevada last year. Again, like with the previous case, DeCastro had previously received an extension to serve the defendants. In his previous motion for an extension, he wrote, "Here, plaintiff's delay in completing service was directly caused by severe PTSD and persistent brain fog resulting from wrongful incarceration, as well as financial devastation that left plaintiff without adequate resources to pursue complex service requirements. These hardships were not the result of willful neglect or dilatory tactics, but rather circumstances directly attributable to the defendant's alleged misconduct. Plaintiff's medical condition only recently improved, enabling him to function normally and take the necessary legal steps to move forward on this case. Additionally, the complexity of serving 8 defendants across multiple agencies and capacities, including Clark County judicial officers, prosecutors, law enforcement officers, and John Doe defendants, further supports a finding of good cause. Courts routinely grant extensions to pro se litigants facing such challenges, especially when the case involves multiple parties and procedural hurdles. In Tuesday's filing, DeCastro did not mention his brain cloud, financial devastation, or his inability to serve 8 defendants across multiple agencies and capacities. Instead, he blamed his lack of service on a single FOIA request he made in early October, seeking the identities of the John Doe defendants that had gone unanswered. The sole reason plaintiff has not served the John Doe bailiff defendants is that the government entity possessing their identifying information has refused to disclose it, in direct violation of Nevada law. This is precisely the type of circumstance beyond a plaintiff's control that justifies extension. See Gesualdi 995F Supplement 2D at 1083, noting good cause exists when plaintiff encounters obstacles in effecting service that are beyond his control. See also Espinosa v. United States, holding good cause existed where process server encountered difficulties locating defendant. Here, plaintiff has done everything within his power, filed timely and proper public records requests, followed up repeatedly, and actively sought the information. The government's unlawful stonewalling is not attributable to plaintiff in any way. Additionally, plaintiff's inability to access the CMECF system, a technical issue with the court's own electronic filing platform, has created additional procedural obstacles beyond plaintiff's control. While plaintiff is working diligently to resolve this access issue, it has prevented the efficient electronic filing and case management that would otherwise be available. Moreover, the irony of this situation should not escape the court's attention. The very government entities that the plaintiff alleges violated his constitutional rights are now obstructing his ability to pursue those claims by refusing to identify their own employees. This conduct, if allowed to stand, would effectively immunize government wrongdoers by preventing plaintiffs from ever learning who violated their rights. DeCastro provided no reasoning as to why he did not serve the named defendants in the lawsuit, and asked the judge to issue an order compelling the state of Nevada to compel the release of the information he is seeking. Upon the granting of his extension, DeCastro promised to 1. Serve all identified defendants, Clark County, and the 5 named individual defendants using the information and procedures confirmed through ongoing research. 2. Upon receipt of the bailiff's identifications from Clark County, immediately prepare and serve summons and complaint on the 2 John Doe bailiff defendants. 3. File amended complaint substituting true names for John Doe designations. 4. File proofs of service for all defendants. 5. Complete all service within the extended deadline established by the court. 6. Continue working with the clerk's office to restore ECF access to facilitate efficient electronic filing going forward. An update. Much like the previous case, DeCastro received a next-day order granting his extension. However, it was not the complete victory he was seeking. Magistrate Judge Brenda Wexler ordered, Minute order in chambers of the Honorable Magistrate Judge Brenda Wexler on November 5, 2025. Before this court is plaintiff's motion to extend time. Under Federal Rules of Civil Procedure 4M, the court must grant an extension of time for service upon a showing of good cause for the failure to timely serve a defendant. See Limoges v. United States, 2009. This court finds that plaintiff has shown good cause for failure to serve because he has been diligent in attempting to serve all defendants. See Townsville v. Contra Costas County, California, 1987. Since plaintiff has shown good cause, he will have an additional 60 days to serve his complaint and summons on the named defendants. As for the unnamed defendants, plaintiff will have the opportunity through the regular discovery process to identify them. See Wakefield v. Thompson, 1999. Accordingly, the motion is granted in part and denied in part. This is an ongoing news story. Wednesday saw YouTuber and activist Regan Benson post a semi-detailed account of her hearing where she pled not guilty to harassment charges against Denver District 3 Commander Joel Bell. These were the charges that were filed after Benson posted Bell's name and home address on a live stream with a vague statement of having a pig roast at her house. A warrant was issued before charges were filed, and Benson turned herself in to jail in Denver as part of a dramatic live stream posted to her channel. Benson's trial for the charges is currently set for February. She posted, Denver, Colorado. The Denver PD anti-Regan Benson speech war rages on. The victim? Commando Joel Bell. I was in court in Denver yesterday for a plea and setting on charge of 18-9-313 subsection 2.7. The plea is not guilty, and the trial date is currently set in February with speedy trial up in May. The authorities were successful in their aggressive manhunt for me as a nonviolent housewife/grandma that bakes cookies on Sundays. They did this through their collaborative statewide extraditable warrant process, where multiple agencies came together and identified the need for swift action to keep the public safe. The apprehension was successful, as I knew I was never going to outrun the authorities, of whom sent their best to complete the job. I have a bad hip, and I really hate to run. I knew that Detective Chelsea Novotny was not going to hesitate to crush my entire pelvis if I did not cooperate. Therefore, I did the responsible thing for just us. I succumbed to my captors. You can see all that go down in the video link pinned in the comments. My captors successfully held me in a cage on the floor with no bond through 18 hours of mental and physical torture. I then learned that I would be restrained per an unconstitutional protection order from ever making contact again with the quote-unquote victim, Commando Bell. I also learned that I would not be allowed to ever defend myself with deadly force, if needed, even in my own home, as my Second Amendment rights have been aggressively stripped from me in order to protect the victim, Commando Bell, as long as he remains a victim. There will be a hearing to discuss that unconstitutional situation of stripping my Second Amendment rights from me on November 17th, 2026, at 10 a.m. in Courtroom 3E, Denver Lindsay Flanagan Courthouse. It turns out I have one of the very best criminal defense attorneys in the Denver metro area, and she keeps winning while representing me. It's because she's an actual intellect in law, whereas my captors, not so much. She, of course, has successfully argued for modifications to the unconstitutional protection order that was granted to the victim, Commando Bell. I think she will continue her success streak with ease. She also has a very keen sense for sniffing out and exposing lying storytellers, a.k.a. cops. Cops lie, tell stories, and write many bogus warrants for me. You think they'd really do that to me? A small education on this unconstitutional law that my captors are seeking a conviction on. Section 2.7, it is unlawful for a person to knowingly make available on the internet personal information about a protected person or the protected person's immediate family if the dissemination of personal information poses an imminent and serious threat to the protected person's safety or the safety of the protected person's immediate family and the person making the information available on the internet knows or reasonably should know of the imminent and serious threat. It has been in existence in Colorado since 2003. It's been charged twice in its history, once in El Paso County and once in Jefferson County. Convictions? 0. That's 0. Zana. Nilch. Carry on, captors. YouTuber and self-professed historical figure Craig Hendry released a video on Wednesday to discuss his final pretrial hearing in his making a false report charge out of Greene County, Indiana, which was held on November 3rd, 2025. Correcting our previous reporting, Hendry was scheduled to go to trial for the charges on December 3rd for the charges and not November 3rd, as we had previously reported. We apologize for the error. The first portion of the video featured Hendry driving to the hearing on Monday. Hendry seemed upbeat and called the upcoming trial a mock trial, as he claimed that he was facing major hindrances to a finding of not guilty of the charges. Hendry stated that it was not fair that the current criminal system requires juries to determine guilt if a defendant's actions matched certain criteria. He lashed out at the system for not letting jurors' personal beliefs and values come into play during deliberations. The YouTuber further stated that the opposition in his case were wealthier and bolder than he was, and had a tendency to use violence in order to prevail. He alleged that the only reason he was on trial was the fact that he would expose corruption of the government, should the government allow him to continue his activism. Hendry ended that portion of the video, picked up again on November 5th, 2 days after the pretrial hearing. He detailed a strange situation where he arrived at the courthouse to find that there were several final pretrial hearings being held in order when the courthouse did not usually have a wait. He claimed that his attorney for another case was present and had represented a separate client and had scheduled the December 3rd trial date with his client before the judge could officially set that date for Hendry. Hendry said that prosecutors presented him with a plea deal, but he would not consider the deal or detail it as it was off the table. Instead, prosecutors approached the defendant, who had claimed the trial date, and gave him a plea deal which was accepted, immediately freeing the court date. The historical figure stressed that he was in urgent need of cash, as he was relying on the state of Indiana to pay for his upcoming deposition in Linton, Indiana, Police Chief Danny Cornett, scheduled for November 7th. Cornett is the officer who brought the false reporting charge against Hendry, and Hendry bemoaned the fact that he could not afford to pay for videotaping of his deposition. Hendry stressed that he was in such poor financial shape that while he wanted all of his supporters to attend his December trial, he would not be able to treat anyone to lunch after his victory. The YouTuber's financial difficulties are reflective of his continued inability to draw donations to his multiple GoFundMe crowdfunding campaigns. On Monday, the market was littered with goose eggs, as there were no donations recorded market-wide for the campaigns that we follow. Tuesday again saw goose eggs, as donations may have been hindered by the government shutdown and continued denial of SNAP benefits to many Americans. Wednesday's single $15 donation to Sean Paul Long Island Audit Reyes's Help Me Fight These Unlawful Charges and Injustice campaign cleared out the Canadian geese that were overtaking the marketplace. This was followed by Reyes's same campaign earning $25 in donations on Thursday. No other campaigns that we follow received donations for the midweek. Those following YouTuber and freedom fighter Jeremiah Payne got a rare treat on Wednesday when the YouTuber released a new outrage video detailing his latest trespass from a business in Clarksville, Tennessee. The video began with a preamble by Payne, who explained that he and his family had just spent $300 in a Clarksville Kroger supermarket, and that they had been followed around the store by the bald, black manager. After paying for his groceries and leaving the store to await their Uber, the store manager asked Payne to stop smoking in front of the store. Payne objected to the request and told his viewers that he was standing 30 feet away from the store's entrance, with the wind blowing the smoke in the opposite direction. Payne further explained that the manager had been mistaken about the smoke from his cigarette blowing into the building, as there were ashtrays positioned outside the building. He then asserted that multiple people had walked in and put out their cigarettes in the ashtrays, causing the smell that the manager had complained about. The footage from the incident started with Payne outside the store, roughly 30 feet diagonally from the store's entrance. The store's manager was standing at the far end of the outside of the store, awaiting the police, as Payne began berating the man. A few minutes later, police arrived and attempted to serve Payne with a trespass notice. He refused to take the notice and stated that the police were conspiring to have him trespassed from every store in Clarksville, much like he said they did in Springfield, Tennessee. Payne informed the police that he was already suing the city of Clarksville and that he had 5 attorneys standing by to add this incident to the soon-to-be-filed lawsuit. He also complimented one of the officers, telling the officers how much he looked like a male sex organ. The officers informed Payne that the trespass included the entire parking lot and were in the process of escorting him out of the area when his Uber arrived. Payne's wife, Samantha, usually a calming element, declined to get involved in the incident, instead getting into the Uber with their 7-year-old daughter and dog Skittles. Payne began to dare the officers to arrest him, pledging that with any arrest he'd be out of jail in 30 minutes. He also disparaged the officers, who inquired why he was shaking so much, as he felt that they were commenting on his medical condition as the video ended. We need your help. Both ReallyCoolSite.org's daily newspaper and our daily newscasts are funded by your continuing donations and what we make from our YouTube AdSense revenue each month. If you'd like to contribute to help us keep the lights on, eating, feeding the cats, defending ourselves from lawsuit threats, and writing news stories to feature on both the newspaper and newscast each day, you can do so via a donation to our PayPal, Cash App, or GoFundMe accounts. If you can't afford to contribute, please watch our videos from beginning to end, like, share, subscribe, and comment. You can help by doing next to nothing, and we thank you in advance for pitching in.